When he asked you for a guest list, did he tell you he was planning a party? Say that again. When he solicited the guest list, did he say then that he was planning a party? I knew there was a bar mitzvah coming up. My answer to him, whoever you invite is fine with me. The only people that are important to me on that guest list are Sammy's friends. The only ones important to you? To me, yes, and my family, Sammy's friends, the neighbors, and everybody else at this point. With what was transpiring, I couldn't care less. So you told him several months ago that you planned this bar mitzvah? I said you can do it. Did Sammy know that? What do you mean, did Sammy know it? Defendant's counsel, I object. The court overruled. Did Sammy know that you told his father, you take care of the bar mitzvah, I am washing my hands of it? Defendant's counsel, objection, misquoting the testimony. He didn't say that. The court, did you say that? The witness, I didn't say I was washing my hands of it. I told him that he could take care of it. In other words, he could pick out the invitations? Yes, and he did. Doctor, will you tell us, is one reason you would give heparin that it works with a good deal of speed? That's right, it acts almost instantaneously. Would you agree with me that Dr. Brown said there was some sort of pathology, that is to say, there was a thrombus found that was likely to be the source of the obstructions that were found in his lung? Defendant's counsel, objection, leading and suggestive. The court, yes, it is obviously leading, but this is an expert witness and he can handle himself if counsel wants to put words in his mouth. What is your answer to it? That's correct. Let's say, for example, doctor, the record was that there was treatment administered at midnight on January 8th. What would be the effect of the heparin on any of the obstructions that were found in his tissue? Can you tell us that? I'd say absolutely nothing. And what would that heparin have done, in our opinion, or your opinion, for the enlarged heart? Can you state with a reasonable degree of medical certainty? Absolutely nothing. What would it have done for the enlarged liver specifically? Absolutely nothing. What would it have done for the enlarged spleen, in your opinion? Defendant's counsel, I object to this incessant leading, if Your Honor, please. The court, no, overruled. Was there an answer? The answer is nothing. To your knowledge, has heparin been called at one time or another a miracle drug? I have never heard that used for it. But isn't it true it may stop further emboli from passing? Is that the intent, in your opinion, doctor, or not? No. What it does is simply prevents further formation of a thrombus in the veins of the tibia, which subsequently could become more or less a problem. Defendant's counsel, I move to strike as not responsive and a purely voluntary statement on the part of the witness. The court, strike it. Is there any medication that you can give that will, let's say, eradicate, like a roto-rooter, I suppose you could say, that is, that will take away the clots that are in the vasculature? Defendant's counsel, Your Honor, may I have a brief idea on this line of inquiry? The court, no, you may not, counsel, not at this time in any event. Doctor, what is the name of the last patient you treated for a condition? Defendant's counsel, Judge, I object. Relevance. The court, it is immaterial, at any rate, sustained. Plaintiff's counsel, if we are now going to talk about what treatment this doctor rendered, I wish to prove that this doctor doesn't treat people. Defendant's counsel, he said he has a chair in cardiology. He is a full professor of cardiology. The court, he is qualified as a pathologist and he can testify vis-a-vis treatment to the area he speaks of. That is all proper in my view. Defendant's counsel, all right, I will wait my turn. Plaintiff's counsel, I just want to point out, Judge, that counsel has 4 different textbooks lined up on the table directly in sight of the jury. I submit that is highly inflammatory. The court, it is not necessary that you comment on that at this time. Defendant's counsel, but Your Honor, is that appropriate? Plaintiff's counsel, do you want me to put them down? The court, the jury will not pay attention to them. You will not be impressed by it one way or another. Doctor, is there some medical treatment in 2002 that was available to clear up these emboli that were found to be in the vasculature? Plaintiff's counsel, was there any medicine that could wash those away? Defendant's counsel, I object to this whole line of inquiry at this time. The court, sustained as to the last question, as to form. Doctor, there are medicines that can help the patient, are there not? There are. Do you have an opinion with a reasonable degree of medical certainty as to Mr. Jackson's prognosis, given his status on January 8, 2002, assuming that he got perfect treatment, assuming that he got the finest medical treatment extant? Defendant's counsel, I object to the form of the question, assuming facts not in evidence, Your Honor. The court, overruled. Hypothetical question. If the facts assumed are not accurate, the jury will take note of it. What is your answer? Do you have an opinion? Yes, I do. What is your opinion, sir, that he had less than a percent chance of living up to 1 year after this episode? Let me ask you, what is the basis of your opinion, sir? Because he had evidence of irreversible heart disease as well as irreversible lung disease. Under the circumstances, it would not be unusual for sudden arrhythmic death to take place in the usual course of events. Defendant's counsel, move to strike as speculative and tangential, if Your Honor please. The court, overruled. That is his opinion.